Welcome to today's talk, where we're going to share tips to help children during high conflict divorces. My name is Regina DeMeo, and I'm a family law attorney in Maryland and DC. I've been practicing for over 20 years and doing child advocacy work for only about 5. But with me today, I have the author of the ABA Handbook on helping children with these kind of cases. Melissa, thank you so much for being here today.
Thank you. It's good to see you.
Yeah, absolutely. So how long have you been a child advocate?
So I've been practicing family law for about 15 years, and probably about 12 of those, the last 12, I've been an attorney for children.
Okay. And just to be clear, there is a minimum level of experience that attorneys have to have and training before they can be appointed as a child attorney, correct?
Absolutely. Every state in the United States has different requirements. In Maryland, in Virginia, and DC, where I'm qualified to represent children, the basics require an active law license, certain level of training, usually a full day, including child development, a certain continuing education requirement each year. And Virginia even requires you to observe other certified guardian ad litems before you can become part of their roster.
Oh, wow. And what's the typical age range for your kid clients?
I have represented children anywhere from virtually infants up to about 16 or 17. Of course, in these jurisdictions around the DC metro area, 18, the child is legally emancipated, unless they have some severe mental health impediments or educational deficits, things that might require a guardian past that age. But it could be for any age child. Of course, it's very different depending on the age of the child as to what their needs are, how they communicate, and the like.
Right. So what is your normal process once the court appoints you as the child's attorney?
Of course. So I immediately reach out to both parents, either their lawyers if they have a lawyer, or if they have no lawyer, then I reach out directly to them. And I give them a good, solid understanding of my general protocol going forward, so that they understand what my ethical obligations are to the child, to them, because if they have an attorney, I am also an attorney in the case, and I can't legally and ethically communicate directly with them if they have a lawyer unless they have permission. I then have conversations with both parents, with or without their lawyers, depending on their desire. And I gather information about the child, about the way they communicate, about the issues in the case. I review the file, and then I go into meeting my child client. And then I'll meet with the child. The initial meeting is usually just the child getting comfortable with me, figuring out who I am, why is this person asking me these questions. If the child's very young, they might not even understand I'm their lawyer or what a lawyer is. And then I'll proceed to meet with the child in a series of different environments, with the parents at their different homes, with other relatives, with friends, at school, at their soccer games, at their school plays, wherever it is that they are and that their life is, so that I can get a good cross-section of seeing how they interact. And finally, I'll speak to other people. The parents will usually designate coaches, neighbors, family, relatives, educators, doctors, who are helpful in actually getting a broad picture of the child and their well-being. And I'll voluntarily speak to all of those people, as many people as you want me to speak, so that I can get a good, solid understanding.
And who is typically paying for your fees while you're doing all of this work?
Right. Well, the court decides who pays for the fees, and it usually, in most cases, is the parents. And the court usually would designate which parent or both parents and in what percentage they would pay an hourly rate for the work that I do. In some rare instances, it may be that the county or the jurisdiction where I'm practicing will cover the costs, or that the case may be through a special program at the courthouse that would be pro bono.
And what are the typical cases that would, because it's a pretty high ask to bring on a child's attorney to be part of this case. So what would cause the court to want to bring on an attorney for the child?
Right. You're absolutely right. There is a lot of expense, and it is adding a whole nother person to this child's life, which can be stressful for this child. So usually I found that the courts are more likely to bring on a lawyer for the child if there is an extraordinary amount of acrimony, if a parent requests a relocation of the child outside of the jurisdiction, or it's just a very complicated high-level case where there are a lot of other individuals that the court thinks is important to bring in, but is concerned that maybe, you know, the educators, the doctors, they're not being heard. Having someone who is from many ways more neutral in regard to the child, having the ability to talk to those individuals is very important. And so the court will often consider appointing a lawyer for the children in those higher conflict cases.
And do your kid clients often have to testify, or is it basically your goal to have them not be in court?
Right. I think my ultimate goal would to have them never step foot in court, because I can imagine it is extraordinarily stressful. It's stressful for the parents as well. But there may be certain rare circumstances where it is necessary or very important to have them testify. And in that regard, you need to be very prepared and make sure the child is very well prepared, and that you do everything to help with their concerns about what they're going to see and what they're going to feel and experience.
What would you say is the biggest challenge for you in these cases?
I think the biggest challenge is when you get a situation where perhaps the law is not designed to actually help the outcome. Maybe the family needs something special that the law typically wouldn't put in place, a special intervention by a professional or things like that going forward. And, you know, the difficulty is if you as the lawyer for the children feel that this is a good outcome and a good process for the family, but the court can't give it to you, that is extraordinarily frustrating for the family.
Do you find you play a little bit of a mediator role sometimes?
Oh, absolutely. You know, because I have a unique perspective. Parents, they'll have talked to their children, but they might not be hearing exactly what their children are thinking or feeling, because children, when they're in these very stressful, high anxiety situations, they may be telling the parents what they think the parent wants to hear in order to help the parent get through their own difficult situation. And because of that, I can bring a different perspective to the situation that maybe the parents hadn't considered when they were talking things through with each other.
What would you say is the most enjoyable part of this work?
The kids. I mean, how can you ever have a bad day at work when you get to maybe go and have some ice cream with a child that's your client? That's definitely the best.
Okay. So if people want to contact you for more information about this work, what's the best way for them to reach you?
They can take a look at my website, which is mkfamilylawfirm.com. And they can send me an email, which is on the website, and then you put up a slide that also has it.
Great. Melissa, thank you so much for doing this work.
Oh, thank you. And thank you for your work doing this as well.
Thanks. So thank you all for tuning in. And if you want to follow more of the YouTube videos that we've done as a special COVID-19 series, please follow me on social media as Gen X Smarty. Melissa, stay well. And thanks again for taking time to do this today.
Thanks, you too.
Absolutely.